In this special edition of Hometown USA, we examine the laws that currently regulate cable television and how the Federal Communications Act of 1984 will affect what we see over the cable. The tape was produced for NFLCP by Fred Johnson.
Listening to all the recent and excited talk about post-industrialism, the home entertainment revolution, and the information explosion, a person could think cable TV and other advanced kinds of telecommunications are an entirely new phenomenon. This is hardly the case. Telecommunications has been a steady and purposeful part of technical innovation for the last 100 years. Cable is merely the latest in a chain of developments that began with the telegraph. Growth in the telecommunications industry has paralleled the growth of transportation systems, often being built simultaneously with roadways. Throughout its history, America has been just as concerned with the speed of moving information as it has with the speed of moving freight and people.
Vector, this is ground control.
Ready.
Check.
Inches in diameter.
The next generation of telecommunications is already upon us.
In the 1950s and 60s, the convergence of transmission capabilities with radio, television, and computer data processing brought about the present surge of electronic communications. Now, with interlinking via satellite, microwave, fiber optics, and cable, we have a worldwide communication system with a potential capability we have not yet begun to touch.
It's been a number of months now since the passage of the Cable Communications Policy Act of 1984. The act was a significant victory for the public. For the first time, Congress mandated the city's rights to require access channels and also their right to enforce those requirements. The legislation was clearly a compromise that was a very difficult process, a 3-year process indeed. Now, one would think after the passage of such legislation, everything would be very clear-cut and we would see answers to all the questions that many of us have had over the years. But that, indeed, is not the situation at all. Finally, it's going to be the courts that determine some of the issues that were addressed in the bill, but issues that are now being challenged by the cable industry.
when the Supreme Court decided that the FCC did not have jurisdiction to mandate access to cable, the court did suggest that if Congress wanted this as a requirement, Congress would have to pass such a law. And so, in effect, the Supreme Court said to Congress, decide. Well, Congress has now decided. Congress has decided that we should have access. That's very good news for us. We may have objections with other parts of the bill, but for the first time we have access mandated in legislation on a national basis.
Before this bill was passed, it was questionable whether Congress was interested in broadening the public's First Amendment rights in keeping with the new technologies. This bill would appear to indicate that Congress is very interested in seeing the traditional First Amendment values of diversity of information, public expression, individual self-expression encouraged through making possible the use of cable facilities.
The most important thing about the cable bill is to realize it's a compromise. It's not a deregulatory bill. It's certainly not a pro-industry bill. The final bill, not the earlier preliminary drafts that were discussed and attacked, but the final bill is a fair compromise that protects access, protects the consumer, and protects the industry. It truly is a balanced bill.
The new act greatly improves the atmospherics surrounding cable service in this country. I think it clarifies many issues which were simply unstated and unresolved prior to the act. That makes me optimistic about the effect the act will have on the level and quality of cable service in everyone's community. I think the relationship between cable operators and the public they serve will be improved because of this act. The legislation resolves 90% of the issues that were outstanding. There are definitely ambiguities remaining. There are definitely uncertainties remaining, and we're going to see some substantial court cases resolving those ambiguities over the years ahead. But overall, we are dealing with a much improved environment, which I think will allow a step away from confrontational tactics between the cable company and the public, and a step toward cooperational tactics.
While these issues tend to come up in isolated communities or in cases filed before the FCC which involve just maybe one or two communities, the impact of some of the litigation in court cases, the impact of some of the developments at the FCC can affect access operations throughout the country. I think one thing access organizations should be considering is there a way we can together present a unified front effectively to present our case for access?
The single most important section of the bill is called Section 611 for PEG access. That bill authorizes local governments and state governments to require public educational and governmental access. That's important for two reasons. First, it is the first statement by Congress that PEG access is constitutional. In other words, in Section 611, we have the Congress of the United States saying that access is constitutionally not only permitted, but is constitutionally desirable since it advances speech, increases the number of speakers. Secondly, it lays out a framework for municipal governments and state governments to require access.
Indeed, this is the firmest provision of the bill, because when cable companies go in and they seek modifications, the section that they cannot change is the channel capacity for access. And there are companies all over this nation that have gone in saying, well, you know, the franchise calls for us to provide 8 access channels, but we really don't think that's necessary. And besides, we'd like to use the channel for X. And, you know, we're having our own financial problems. Why don't you give up a couple of them? Cities need to know now, people in the community need to know that Congress intended that whatever channel capacity was set aside in the original franchise for access by people in the community is firm. It's firm until the local franchise authority agrees to let go of it.
The Act sets aside various types of modification requirements depending on what is being modified. For facilities and equipment, that is the hardware, channel capacity and the like, that requirement can only be modified if the requirement becomes, quote, commercially impracticable, unquote. That is a lawyer's phrase out of contract law, out of the Uniform Commercial Code.
I think it's important for access users to recognize that it will be difficult for an operator to show that it's commercially impracticable to provide access facilities and equipment. And I think access groups should be reluctant to automatically accept an operator's assertion that it will be commercially impracticable. More important is that an operator is going to be going to city councils to attempt to get modifications on the franchise, not under the bill, but under a general claim that the access provisions in a franchise, for example, create a hardship. That seems to be a more serious and actually more of a political question, and will require existing access groups to develop their constituency, to work toward developing good relations with the city council so that they can make a case that access should not be cut back in their communities.
Commercial impracticability does not mean that a cable operator's profit margin is lower. It does not even mean that he is now facing a loss. Commercial impracticability means that circumstances have changed so that the cable operator is required to do business in a radically different way. For example, it would be commercially impracticable if a change of circumstances prevented an operator from using utility poles and was forced to use underground cables at 10 times the expense. A second provision of commercial impracticability is that it must be entirely unforeseen by the cable operator.
We're not talking here about a simple change of circumstances. We're talking about something close to an act of God. The cable company has to come in and say, there's just no way we could have known about this. And I'll tell you, because cities around the country aren't aware of the teeth in this provision, cable companies are getting away with murder. They go in there, they say, it's costing us too much, come on, be reasonable, and cities cave in because they think that a bill has been passed saying the cable operator can modify provisions of the franchise. This will be a very important area of negotiation and perhaps of litigation in the years to come, because some of those original franchises were quite enlightened. They were the product of 1, 2, 3 years of negotiations, ascertainment of community needs, an understanding of what other cities were getting that this city wanted. Right? Several years later, people begin to wonder, is all this possible? And the cable operator comes in and says, we cannot afford to do this. Well, now there's criteria. And the city government need not cave in. It can say, listen, what's the trade-off here? We're not just going to say yes to this. What are you promising us? Why should we give in? Why does it make sense for all concerned? Unless, of course, it's been an act of God, in which case nobody can quibble.
Now, there are different requirements for services, for programming requirements. Either existing franchises which require specific programs, or future, or franchises which follow the law, which require broad categories of programming, such as children's programming and news programming. They can be modified as long as what remains, what follows, is of a like level mix and quality. In other words, they can be substituted if the consumer, subscriber, viewer is not harmed. There is a third type of franchise provision in addition to hardware, facilities and equipment, and programming, such as services. Hold on, I'm going to get the exact language. That is a third category called services related to public, educational, and governmental access. Services related to so-called PEG access may not be modified, period. In other words, a requirement of channel set-aside for access or services such as staffing for an access center, those may not be modified. There is one important addition to the law of modification. While the law sets up a framework for modifying franchise provision, the city or the franchising authority is always permitted to permit the cable operator to ease up on certain requirements. In other words, the cable operator and the city can always negotiate between themselves to modify a franchise. If they are unable to agree, then the Cable Act's modification provisions kick in.
The bill provides a lot of opportunities for access groups to outreach to their communities, if you will. One of the more imminent opportunities, I think, is that cities are required to establish rules under which a cable company will be allowed to recapture the channels devoted to access. Now, the question will be, what form do those rules have to take? Well, traditionally, you've seen some rules like when 20% of the channels are occupied 80% of the time on 3 or 4 days of the week, that means it's in use. That's the sort of thing you see a lot of times in franchises. What access groups might want to consider doing is convincing their city to go a little bit further, to condition recapture on an operator's provision of support for access. For example, has the operator made any effort to promote the channel? If not, why should the operator be allowed to recapture it? Has the operator made any effort to actually train people to use the cameras, or at least provided sufficient equipment maintained in good enough condition to allow such training to go on? If not, why should the channel be recaptured?
The franchising authority is permitted to set up several different types of rules and regulations governing access. The most prevalent will be so-called traffic cop regulations, such as first come, first serve, one slot for half hour, one slot for hour, one slot for series. The second type of regulation the government can set up are called fallow time requirements. These are requirements which permit the cable operator to use unused access time. Now, something very important for people to realize about the fallow time provisions. They do not, and logically should not, kick in the instant a cable system is turned on if there are no access programming. History has shown that access takes a while to be developed, and it would be very difficult to kick out a cable operator who has lodged himself or herself onto the public's access channel. What these kind of rules should state, therefore, is a certain time span, a 2 or 3 year period whereby access can develop before the cable operator allowed to take over the access channel. Now, the law requires the cable operator to give up an access channel once demand has developed. However, we all know how difficult it is to dislodge a cable operator. The third type of regulation, which is slightly more problematic, is subject matter. Can, for example, a city say one channel for senior citizens, another channels for minority programming, another channels for general public access? The answer to that is not in the Act, but rather in the First Amendment. It is impermissible for the government, any government, to select what topic can be discussed in public forum, in public proceedings. However, if there are enough access channels so that nobody is being silenced, it seems reasonable, if not desirable, to allow a few, though not by any means all, access channels to be segregated by subject matter so that a certain audience can find a certain program there at a set time. Obscenity laws are radically different now after the Act has been passed. First of all, the cable operator is not liable for any access programming that the cable operator did not censor, edit, or work on. In other words, if the cable operator merely carries access programming, the cable operator is not liable under the obscenity laws. However, the cable access programmer will be liable for obscenity. This is very important for several reasons. First of all, there is now, for the first time, a very stiff federal penalty for public access obscenity. Let me rephrase that. There is now, for the first time, a very stiff federal penalty for obscenity over cable television. It's a $10,000 fine, it's a jail term. This is notwithstanding what the local government or the state government requires. There's now a federal obscenity law which the cable access programmer will be liable for. Additionally, the state and the city can also impose their own obscenity laws, so an access programmer who is not careful could theoretically face charges at the local, state, and federal level.
I'd note that under the bill, there is a provision which exempts the cable operator, and I would presume an access corporation, from liability for obscenity to the extent that it's not involved in the production of the programming which is deemed obscene. So you can begin to see that depending on what role you take, your vulnerability to challenges under the law increases as you become more of a producer of programming that could be labeled obscene. The problem being, of course, that as you go to the other extreme, which is close your eyes, let anything go on, you run into the political problem. It's a balancing act that will depend on your community. It's a sensitive issue, and it's one that I don't think will go away.
You have to draw the distinction between whether the franchise is grandfathered or whether it's a new franchise. With respect to grandfathered franchises, the language is very clear, excluding public support for public access as being offset against the franchise fee. But with respect to new franchises, the exclusion language only applies to capital costs related to public access. That creates the implication that any non-capital expenditure on behalf of public access in a new franchise should be treated as a franchise fee offset. Now, the answer to that problem, again, is, I think, to take the position that public access is part of the service commitment. Even if the actual dollar amounts required to provide that service are enumerated in the franchise, it is part of the service commitment by the operator and is in no way a payment in kind to the municipality for two different reasons. One, it doesn't accrue in any sense as a financial benefit to the franchising authority, so it doesn't look like a tax fee or assessment, which is what you would expect a franchise fee to be. And the second argument being that the Act is very clear that service levels are fully enforceable. And just as a commitment by the operator to provide 3 pay movie channels may end up costing the operator some money, similarly, the promise to provide and support 3 public access channels may cost the operator some money. But in neither case should those expenditures by the operator to fulfill their contract commitment be treated as a franchise fee offset.
One of the goals of the First Amendment is to encourage the widest diversity of information sources from antagonistic voices. When we take a look at the First Amendment ramifications of the cable bill and the position that the cable industry is taking with regard to their, in quotes, telepublisher rights, we see a direct conflict ongoing. Essentially, however, the courts have traditionally upheld structural regulation of the media, and requirement of access channels, or the ability of local authorities to require access channels, fits squarely within this consistently upheld structural regulation philosophy. Now, still the cable industry will say, but we're telepublishers, and by requiring access channels, you are essentially taking from us our property. But if you step back from that and look at it for a few moments, there's another reality that evolves. The cable company controls the content of all the vast bulk of the channels that they carry on their cable systems. Now, the requirement of a small number of access channels for the public's use does not, in fact, infringe on the First Amendment, but in fact enhances the First Amendment, because it does not impinge on the cable operator's ability to express their viewpoint. In fact, by having a certain small number of channels designated for access purposes, it allows the cable operator to control the vast majority of the channels and still allows the public to have access, and thus, again, enhancing that First Amendment goal, which is a diversity of voices and a diversity of speakers.
Cable companies made it very clear that they compared themselves to newspapers. And if there's no regulation of newspapers, there should be no regulation, including access requirements, for cable. So there I'm optimistic. I'm also optimistic that cities are going to get more sophisticated about cable, because they now can find out about their rights. And we must get rid of this idea that the Cable Act is simply a deregulation bill. There are possibilities here for effective local enforcement. Public participation to be sure that the available channels for public, governmental, educational, and least access are put to good use. That the franchise authority makes use of authority that it has to require general categories of programming. It cannot require a specific program type. It cannot require that the system carry ESPN or C-SPAN or whatever. But it can say that based on an ascertainment of this community, we need more local origination programming. We need more local news or public affairs programming. This is authorized. This kind of requirement is authorized by the legislation. So, in general, I think those cities that have been negligent and irresponsible may continue to be so, but that those cities that have felt somewhat helpless in bargaining with the cable operators, if they're willing to get help, to educate themselves about this bill, if people in the community will find out about the role they can play, that we're here talking about a set of relationships with regard to a communications medium that will be very positive, very exciting.